Hello everyone! Today we're going to talk about a case which deals with valid warrantless arrest. We are going to discuss the case of Mario Veridiano versus People of the Philippines. In this case, a concerned citizen called a certain PO3 Esteves, the police radio operator of the Nagcarlan Police Station, informing him that a certain alias Baho, who was later identified as Veridiano, was on the way to San Pablo City to obtain illegal drugs. PO3 Esteves immediately relayed the information to PO1 Cabello and PO2 Vergara, who were both on duty. Chief of Police June Urquia instructed PO1 Cabello and PO2 Vergara to set up a checkpoint at Barangay Taytay, Nagcarlan, Laguna. The police officers at the checkpoint personally knew Veridiano. They allowed some vehicles to pass through after checking that he was not on board. At around 10 a.m., they chanced upon Veridiano inside a passenger jeepney coming from San Pablo, Laguna. They flagged down the jeepney and asked the passengers to disembark. The police officers instructed the passengers to raise their t-shirts to check for possible concealed weapons and to remove the contents of their pockets. The police officers recovered from Veridiano a tea bag containing what appeared to be marijuana. PO1 Cabello confiscated the tea bag and marked it with his initials. Veridiano was arrested and apprised of his constitutional rights. He was then brought to the police station. So what is the issue here? The issue here is whether there was a valid warrantless arrest. What did the Supreme Court say? The Supreme Court held that petitioner's warrantless arrest was unlawful. There are three grounds that will justify a warrantless arrest. Rule 113, Section 5 of the Revised Rules of Criminal Procedure provides that a peace officer or a private person may without a warrant arrest a person, first, when in his presence the person to be arrested has committed, is actually committing, or is attempting to commit an offense. Second, when an offense has just been committed, and he has probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested has committed it. And third, when the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment, or is temporarily confined while his case is pending, or has escaped while being transferred from one confinement to another. The first kind of warrantless arrest is known as an in flagrante delicto arrest. The validity of this warrantless arrest requires compliance with the Overt Act test, as explained in COGAED. For a warrantless arrest of in flagrante delicto to be effected, two elements must concur. First, the person to be arrested must execute an overt act indicating that he or she has just committed, is actually committing, or is attempting to commit a crime. And second, such overt act is done in the presence or within the view of the arresting officer. Failure to comply with the overt act test renders an in flagrante delicto arrest constitutionally infirm. The warrantless search cannot be justified under the reasonable suspicion requirement in stop and frisk searches. A stop and frisk search is defined as the act of a police officer to stop a citizen on the street, interrogate him, and pat him for weapons or contraband. Thus, the allowable scope of a stop and frisk search is limited to a protective search of outer clothing for weapons. Although a stop and frisk search is a necessary law enforcement measure specifically directed towards crime prevention, there is a need to safeguard the right of individuals against unreasonable searches and seizures. Law enforcement did not have unbridled discretion in conducting stop and frisk searches. While probable cause is not required, a stop and frisk search cannot be validated on the basis of a suspicion or hunch. Law enforcers must have genuine reason to believe, based on their experience and the particular circumstances of each case, that criminal activity may be afoot. Reliance on one suspicious activity alone, or none at all, cannot produce a reasonable search. Moreover, petitioner's silence or lack of resistance can hardly be considered as consent to the warrantless search. Although the right against unreasonable searches and seizures may be surrendered through a valid waiver, the prosecution must prove that the waiver was executed with clear and convincing evidence. Consent to a warrantless search and seizure must be unequivocal, specific, and intelligently given.